Hello and welcome to Legally Speaking with me, Tarun Nangia. Now we begin the part 2 of our discussion on democracy, courts and rule of law. You've seen Justice Sikri share the Indian example. Now a lot of my viewers, our viewers, not acquainted with what happens in USA. Could you share with us, have courts in USA been called upon to tackle these kind of crises, specifically with regards to governance, specifically with regards to issues that people have? What has been the US example, or it differs state by state? Could you share with us?
Thank you. Well, I'm happy to talk about some of the history of the rule of law in the United States. Yes. And let me say that in doing so, it's important to recognize, as Justice Sikri has said, this concept that we share, as Justice Cooper said, of democracy being we the people, because that's a powerful term. It means that there's an assumption that the people are not going to be protected if you only have the executive branch.
Okay.
Democracy is not going to be healthy if you only have the legislative branch.
Yes.
You need an institution called the judiciary that will guarantee the rights of, and this is where it gives me a lot of inspiration and, as we say, chicken skin to think about. Where does Mahatma Gandhi come from?
Yes.
Where does Ashoka come from? It comes from a history of standing up for the underprivileged in a huge population called India.
Yes.
So let's move to the United States. We have the same assumption that we have to be careful about our government.
Okay.
The state, as Justice Sikri said, we have to be careful.
Careful.
This underlines all the relationships between the judiciary, the executive, and the legislature. We have to be careful not to give government too much power. And the guardian
Yes.
of that are the men and women who are trained. And when I hear Justice Sikri, it's just an echo of the justices of the India Supreme Court who have been trained to be independent. Yes. And vigilant under, for example, public interest law, which is developed in a robust, powerful way in India and also has developed in the United States. But it means that people left out, people that are poor, people that are oppressed, have a voice with the courts. In terms of examples in the United States, imagine we had a history of slavery.
Okay.
What is the role of the court when you have the executive and the legislative branch that are pursuing the policy of slavery? It was challenged.
Challenge, yes.
At first, because of the pressure, institutional pressure, the court said that slavery is constitutional. That was hundreds of years ago.
Yes.
But then it's a living constitution. Then principles that are quite clear through, I think, a straightforward human conscience prevailed. And judges were independent and said that slavery, of course, is unconstitutional. If you move forward to an industrial era, this idea that there were poor people or children in factories that were being exploited, they needed to be protected. There was legislation passed that went to the Supreme Court because the government, the executive, wanted no regulation of business because it might make business less efficient. The courts had to decide. And at first, because the men and women came from this sort of industrial community, the court said it's unconstitutional to regulate the conditions of children working in factories.
Is it so?
At the beginning.
Yes.
So when we look to India and we see the tradition of judges being so independent and willing to declare that the Constitution means you have a right to life, you have a right to a clean and healthy environment, yes, it helps fortify our judges. And our judges eventually decided that, of course, under the Constitution, it's probably good policy to control the conditions of children working in factories because you can't just leave it up to the powerful industry. And finally, we now have a challenge on the ultimate public policy issue, standing up for a whole generation of people that are less than 40 years old. And where are most of those people in the world?
India,
that are less than 40 years old? They are India by far, with 850 million people, a lot more than in the United States.
Yes.
But Do citizens have the right to come to court and demand a clean and healthy environment?
Yes.
It's not so clear right now in the United States anymore.
No?
But it's clear in India.
In the US, it's not clear as yet.
It's no, and this is part of the reason that Justice Cooper and I are here, because it's so important for us to see the way India handles these kind of problems.
Very
But this is a very, very fundamental issue of great
A
importance.
bunch of interesting points by Justice Wilson. I'll go to Professor Rajkumar.
I want to quickly respond to
Yes,
what
yes,
Justice.
yes.
You see, it's very important to also recognize that when you look at our own courts, while Justice Wilson is right to say that the demonstration or recognition of the right to clean and healthy environment in the US context is not so clear, and the Indian context, our courts have consistently recognized that. But we should make an important distinction between norm creation and norm recognition does not mean norm enforcement or implementation. It continues to be the case that a lot of, let's say, directions that have been issued by our courts, recognitions relating to what is right and what isn't, have not been implemented effectively. So we have a situation in our country, and that's a far more serious situation, in which on a number of issues, particularly in relation to economic and social rights, including on issues relating to environment, the court orders and directions have not been followed. And there is an exponential rise in the norm creation, but when it comes to actual norm enforcement and implementation, we are slowly becoming a very weak state. And unfortunately, our courts don't have enough mechanisms, because to a large extent, it's important, Tarun, to recognize that democracies, to a large extent, work best when all institutions are by and large performing its role and responsibility without the force of law. In the sense that, as a famous jurist said, rule of law works well in societies which already respect the law.
Yeah.
So in some ways, if in environment, it's a very important area, because all of us grew up in law schools, reading those famous judgments on range of issues where we expanded the right to jurisprudence, including Article 14 and 19 and 21, which we are very proud of it. But the fact remains that we are increasingly entering into a stage where courts can keep making these normative judgments, but the institutional capacity and executive responsibility to enforce and implement these judgments are weaker, and I dare say we don't have enough mechanisms to ensure that the executive is held responsible.
Very, very important point by Professor Rajkumar. I've personally experienced this, because in my career, say for about 15 years or so, I have seen that courts have, in a sense, have orders upon orders where they have delved into issues like clearing of garbage from certain societies, to supplying water to non-VIP areas where, because water is supplied to certain enclaves in cities where a certain section of society lives, where government officers live, or in a sense, the better off neighborhoods of cities. So all kinds of issues courts have been getting involved into. Of course, not suo moto, people have been aggrieved and they have approached the courts. But of course, it is for us to see, and many times I have personally witnessed that these orders are not implemented due to sheer executive, there can be two kinds of inferences drawn upon: unwillingness to implement with whatever they have, or simply saying that there is not enough wherewithal to implement.
Resources are not
there.
I'll use the word apathy and indifference.
Apathy and indifference. So going to Justice Cooper, and you've seen all other panelists speak, and what would be your last word on this issue?
Okay, so I guess two things.
Yes.
One would be, one of the things I'm acutely aware of speaking to jurists and speaking to lawyers here is how your system, your judicial system, may be even more overwhelmed than our system. We have a much smaller population, and we're nowhere near the size of India. Yours is just of such great magnitude. We also have a state and federal system. We basically have more courts, and we have more judges, I think, per capita. And as a result, they don't have the sort of dockets. I was so surprised to hear that the Supreme Court has an immense docket each year. Your Supreme Court.
Just for your information, in India, I think it is 21 or 22 judges per million of population, whereas it is 125 in US.
125 judges for a million's population?
Yes, yes, that
I
is
know
the difference.
I know under the constitution of my state, you get judges, I think it's 1 per 50,000 people.
That's
Yeah.
So there's a lot of difference between our two
Yeah.
democracies.
So that is amazing. So you have some challenges and some handicaps that we don't have.
Infrastructure issues aren't there, and you see the number of judges are more.
Right.
One question that I have,
Sure.
I mean, it just came to mind purely out of my curiosity. In India, there is a paucity of data which our judiciary can rely upon to deliver judgments. And many a times it's given out of whatever is presented before them. Is that a problem in USA? Or are there enough reports available on various issues which are well researched?
Yeah, we have an extensive case when cases are now easily found. Used to be one time you had to only go to a law book and it could be
And that's
difficult.
where I would like to get Professor Kumar in,
Yeah.
because the role of universities is very important to generate such data. Does
So,
India
so one of the big challenges in India is that not only for courts to make judgments, even for policy making. I mean, evidence-based policy making or evidence-based judicial decision making is unfortunately not prevailing because most of it is opinionated.
Yes,
And
it's
so when you
opinionated,
have an
not data.
opinionated system whereby if you think, like for example, if you are, if you look at today's context, there is of course a legitimate fear among countries around the world about, I'm just giving this as an example, coronavirus as a major challenge that we are facing today. Now, if you look at, and if you base this current prevailing, phenomenon for policy making, you might end up getting very skewed results because we know that in India, approximately 650 people die every day due to road accidents.
Yes.
650 people die in road accidents every day. You calculate that, we're looking at 1.5 plus lakh per annum.
I've actually come pretty close to being one of those trying to cross the street in Delhi. So, especially when we look when you cross, we look the wrong direction. So I'm going to make sure I'm not one of those.
But if you look at, for example, some of these diseases, say the current ones, the number of deaths are far lesser. Now, what I'm trying to say is that we need to have a robust evidence-based policy making, but also judiciary to be presented with the data. Unfortunately,
The
both in terms
universities-
of legal research, lack of scholarship in relation to academic writings are relatively lesser because, and hence judges also are most of the time presented with information from both sides of the lawyer
And whatever they have to
community
decide.
and whatever
Yes.
they could, their clerks
that's-
You
could
see,
that's
good
very
thing is
involved.
now on some of the projects, I would commend many law schools,
They are
Care
doing-
Law School, including some national law schools.
Yes.
And the students are taking those projects.
They are
coming
coming
out
up
with
with data?
empirical research on
Absolutely.
that basis data, and in some of the cases they have intervened and they have provided that data to the courts.
I think Judge
Like
Wilson,
on-
I'm
yeah.
sorry.
And they have cited,
Yeah.
for example, the National Law School in Delhi
Delhi
on the
on
death penalty
death
matter,
penalty, yes.
on the 377 General
Yes.
Global Law School's own faculty members
Yes.
have been. So this is, but in a country where there are 1,600 law schools and so much of need for this kind of, research coming out, unfortunately, it's woefully
And
inadequate.
I would
Let's not-
also,
Michael,
before I go to
sorry.
Justice
I'm sorry.
Cooper, no, before I go to Justice
Got
Cooper for a
got
question, I
excited.
would like to also make a point that the industry's involvement, industry has been wanting in its involvement in a sense to invest in these schools to fund such projects. I don't see industry in India really coming forward to fund such studies in universities, which I think may be common in US. I am not aware.
No, you are absolutely right. I would call it not just industry, generally the corporate business sector, including law firms, corporations,
They don't fund-
business
they don't
enterprises.
fund these studies.
They have seen law schools at best recruiting grounds for their,
That's all.
That's it. They don't see this as, institutional ecosystem.
But
for
I
research.
see now little silver lining. Few law firms I have seen
They are?
associating.
No, I'm not going to Justice Cooper, and we have little time left, so we'll go for a final round of questions. Should courts be in the business of making policy, or do you think that courts don't want to make policy? It is thrust upon them by executive inaction, and they are forced to play that role. And there have been many cases. For example, in India, there is big corporate lobbies which in a sense have disproportionate influence on governments across the world. Case in point is the midday meal program or the school food program, where many a times many corporate lobbies talk about serving children biscuits instead of nutritious meals. and you have had courts stepping in, in a sense saying, no, this policy is not right. You can't serve children biscuits, you better serve them meals. But this is a very small example. It can be in industries as diverse as mining, to water supply. How would you look at this whole issue of courts making policy or interfering in policy making by governments?
The way I would look at this question is that certainly in the U.S., courts have been in the forefront of social change. And piggybacking on your question about law schools and data, some of the material that courts have relied on, some of the most valuable material have been law review articles done by students, because in law schools, that's where some of the greatest ideas come. You have young people who are confronting ideas. And so some of the social change and decisions that are distinctively moving progressive, let's call them progressive, rely so much on law review articles. And I think Justice Wilson
you
would
have
agree.
relied upon them
Right.
for a lot of?
But yes, absolutely. But when talk about social change, one case comes immediately to mind. I think Michael would agree. Brown versus Board of Education. And that was a situation where we, as one of the vestiges of slavery, which was the worst stain on our history, we had an enduring stain, and that was legal segregation, not de facto, actually legally ordered desegregation. We had separate, quote, separate but equal schools that of course weren't equal, and they couldn't be equal because when you had black children and white children going to different schools, it was just wrong. It wasn't what we as a society needed. It was unfair, it was discriminatory. But that wouldn't have changed, or it certainly wouldn't have changed as fast if it was left up to legislatures. It wouldn't have happened, never would have happened in the South. It's hard to say if it would have happened anywhere. But it was because of a constitutional interpretation that was unanimous by the Supreme Court in Brown versus Board of Education that we had to see change in this country. So in the U.S., that is, I think, the prime example of how the course of our society changed as a result of judicial, you can call it intervention, you can call it policy making. I would prefer to call it interpretation of the principles of our Constitution.
So you call it a living constitution?
And that is a major debate that's going on in the United States.
Versus
Yes, as there's said, textualism versus originalism. It is, and then there are those who say, no, you can't just be stuck by the words, or you can't just fixate what did a bunch of very smart and noble people back in the 18th century think. You can't look at that. Times have changed. You have to look at it in terms of an evolving constitution, a constitution that changes.
So courts have the very difficult task of treading that path?
Absolutely, and there is a huge division between judges as to what methods applied, and I'm sure you have that as well.
This is a debate going on even today for last number of years in United States, and the judges are divided. Whether to go by the text of the Constitution, and originalism means the Constitution in 1776 or 77, whether we should be stuck to that period and what was the framers of the Constitution thought about a particular provision, or it should be a living Constitution, and we have to give the interpretation in today's times.
But Justice Cooper, do you face that dilemma when you are sitting in judgment on so many cases of relevant importance? Do you have that dilemma in your mind?
I think we always have that dilemma, and I think that's it, because we are not there to make the law, we're not there to write the law, we're there to interpret, enforce, but the question comes up, interpreting a living constitution might be a lot different than interpreting a static Constitution.
But how would you see it in the Indian context?
You see, and I was telling you 3 stages, and I had not come to 3rd stage. I think this is relevant to 3rd stage of the PIL. When I said first was for the underprivileged and all those. Second was when of a natural environment and the protection of that. And the 3rd phase, if you see in last 15 years or maybe 20 years, that is on good governance.
Good governance.
That is where the court thought, and of course, going by that, this is what is expected of the executive. and of governance of the country. And when I said to you about the directive principles of state policy, etc., which I mean, all these things of welfare measures are expected of the executive, and likewise day-to-day governance also, where the court started enforcing that principle of good governance. Now, in that sense, you take the example of 2G, take the example of coal cases, etc., where these, I mean, coal mines leases were given, or 2G spectrum which was assigned, etc. But the court found in those cases that, look, the manner in which it was distributed, it is not a bounty, that it is not the will of the executive, that person sitting there should, if I like your face, I should give it to you, if I like don't like Rajkumar, I should not give it to him. So therefore, it has also to be governed by the principles which are there in administrative law, and which are well recognized principles, how administration should be run. Now here, sometimes what happens, it is, I would say again, there are two, I mean, streams of cases. One is where fundamental rights or human rights of the people were to be enforced. There, sometimes policy is also made. Take Vishakha case. Where the court said that it is a sexual harassment at workplace, women's sexual harassment at workplace, and the court found that there is no law. Although India was signatory to CEDA, but no domestic law is framed on that. So how to implement it? So that so in the cases of human rights, the court has gone to that extent, and have even in that case, the court said that this would be the law till the time Parliament enacts the law. So court even assumed the power of the legislature and enacted the law.
So you mean court is merely filling up shoes where the executive has no attention?
This may be that second thing which has to bridge between the gap between the bridge the gap between the law and the society. So it may be that society needs it, law is not there, and we are telling the legislature. But what I am telling you is what I wanted, and say second case transgender, where I was party to that judgment, and we said that there is no law for them, and this should be the law till the time. So in both the cases, no laws are made by the Parliament. So therefore, that is one. But when it has come to what I wanted to tell you was that when it has come to the enforcement of fundamental rights or human rights, and the courts have overstepped, that has been welcomed. That because Vishakha judgment is one judgment which was, which got accolades throughout the world.
And that's why.
And even today, people say about that, yes, for the rights of the women and to give them their rights, it's a milestone, no doubt about it. But when it comes to day-to-day administrative functions of the government, and that power is assumed by the courts.
Water, power, garbage, all that.
That is not liked by the executive particularly. Of course, subject to
because we are out of time, but I need a 30-second quote from you. Even though it's not liked by the executive, but if you see the people suffering, crying for help to the courts, should the courts turn a blind eye is what I want to ask.
No, I would say courts should not turn the blind eye, but remedy is, and which I will quote, and I like that Rajkumar had written that article in one newspaper about 2 years ago, that take that cause, do it, but instead of doing it yourself, involve the executive and make them do that task.
Okay.
So that it becomes their task. You are not encroaching upon their power also, but you are enforcing them to do that.
Okay, so we're totally out of time.
Quickly, I want to respond on one matter, on the matters relating to courts deciding on economic matters. In fact, Justice Sikri has a very good judgment on that. I have increasingly seen that even the highest court making mistakes. Unfortunately, the courts don't have enough methods to assess the economic matters carefully. They absolutely don't do law and economic analysis. They simply use their traditional understanding of law, and unfortunately, serious, substantial matters that involve economic apparatus of the entire state, be it in 2G or coal or many others.
That I have commented in
the
program.
In your previous, he has a very good judgment on that. But those cause irreparable damage to the economic status of the country. And once the courts decide something, it becomes very difficult for executive to do anything else.
Justice Sikri had a very long comment on it in our last show.
So if you look at the European experience today, when it comes to economic matters, courts are constantly looking at law and economic analysis. And we need to bring that into
That's where data also comes in, because empirical data is needed, in which we don't have. Justice Wilson, the last word from you on the show. should judiciary be in the business of making policy, or is policy making thrust upon them by executive inaction?
Policy making is the duty of the court as directed by the Constitution.
Yes.
And that policy making is something that's expected by the people to decide what does justice mean
Yes.
under the Constitution. What does the right to privacy mean? What does the right to a clean and healthy environment mean? Those are policy decisions that are required by the court all the time. To me, this is a red herring. Courts obviously have to make policy decisions, but a more interesting question would be, how do they do? Because who else stands up for the disadvantaged?
Yes.
Who else stands up for those who are the victims of the law being applied improperly? So I would say in the overall context, the degree to which policy decisions are made is extremely healthy, let's put it that way, and anticipated by the Constitution.
Okay, the frank observation by Justice Wilson. So that's it for this episode because we are totally out of time, but I would like to thank all my panelists today, Justice Cooper, Justice Wilson, for specially coming down for our show on a special request. Professor C. Rajkumar for, in a sense, ideating for this episode. In fact, I may like to acknowledge his contribution to the ideation of topic, because we're generally not used to discussing episodes in a sense. Now we compared judiciary and democracy in these two nations, which is not the usual episodes that we do on Legally Speaking. Justice Sikri, as usual, has been kind enough at a very short notice to participate on the show. And thank you, viewers, for watching us and supporting us. And we will be back with more such episodes. But that's it for now. Thank you so much for joining us today. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.